and coordinator for this series, Dr. Uday Prakash Warunjikar, other honorable members of Bar Council of Maharashtra and Goa, our resource person for today, Advocate Sadikali Sayyad, my fellow coordinators, and all of you. It is my honor to introduce our resource person, Advocate Sayyad Sadikali. Honorable Sir holds a BSL degree from the reputed ILS Law College, Pune. He holds a LLB degree from Pune University. CL, besides diploma in consumer protection laws. His competencies and experiences include legal and statutory compliances, contracts, writs, agreements, risk management and litigation, legal operations, contract developments, etc. He has rendered his services as a legal officer in various reputed companies. He holds extensive experience in litigation management for resolution of potential business and legal issues before various courts, including Highest Court of India. He has the experience of diverse range of legal, regulatory, and compliance matters which impacted organizations' capacity to achieve its strategic goals. His key strengths include authoring of books on Indian Succession Act and Indian Contract Act. He has been awarded Manav Ratna by Human Rights and Social Welfare Organization at the hands of Central Social Justice Minister Honorable Ramdas Ji Athavle in the year 2022. He has organized various sessions and presented lectures on personality development and team management in D.Y. Patil College. He is recipient of Lifetime Achievement Award of 2012 from Mera Bharat Times for his special services toward legal profession. He was awarded Best Advocate Award by Times Group in the year 2014. He was also awarded the Best Advocate Award at the Pune City from Pune Bar Association in the year 2004. He has written book Islami Kaide on Muslim law with a foreword published by Honorable Justice Shri P.B. Sawant, former Judge, Honorable Supreme Court of India. Sir has also authored a book named Supreme Court on Civil Procedure Code, which is a law relating to Civil Procedure Code. Sir has authored book by the name Handbook on CPC, along with Law of Limitation and Evidence Act. He has to his credit several articles published under his names in various newspapers, and besides this, he is known for guiding on various law topics. There are many more feathers to the cap of our honorable resource person. However, due to paucity of time, I have only highlighted only few ones. I now invite our honorable resource person, Advocate Sayyad Sadikali, sir, to share his knowledge on the topic of Muslim laws and guide the aspirants of the family court exams on this subject. Over to you, sir. Sadiq, sir.
Yes, sir.
You may begin.
Yes. Good evening to all. Am I audible to all of you?
Yes, sir. Camera चालू करा sir अपना.
Okay. Now is it okay?
Yes, sir.
Okay. Good evening to all of you, and I very much thankful to Bar Council of Maharashtra and Goa to organize this lecture series for the students who are giving the exams for the family court judges, and the family laws is well known to all of you, and all of you are studying in the family laws. First off, I welcome all of the members of the participants and the persons who organize the lecture series. So, firstly, while starting the Muslim law, it is a very much wide subject, and due to in these all sessions, it is very few time to elaborate all the Muslim laws topics. But then also, I will try to summarize all the chapters in nutshell. Now, before starting the Muslim law, firstly we have to understand who is the Muslim and to whom we can call the Muslims. So, in the definition of Muslim, or the person who is known to Muslim, is there are three types of Muslims. Generally, we can define who is the Muslim. First, the person who births in the family of the Muslim. The person जिसका जन्म हुआ है मुस्लिम लॉ में, मुस्लिम फैमिली में, he is called a Muslim. One. Second thing, the person who believes in a one God, and the person, the Prophet Muhammad sallallahu alaihi wasallam is the prophet of the Allah. The second criteria is this. First criteria, that the birth, by birth, the person who is Muslim. Another, a person who believes in one God, and the Prophet Muhammad sallallahu alaihi wasallam is the prophet of the Allah. That is the second criteria. And third, the person who is converted in Muslim. The three categories of the Muslims are there. So the person who is believes in Muslim, the laws of the Muslim law is applicable to that family or the person who is the Muslim, or the husband and wife governed by the Muslim law. Now, in which sector Muslim laws is applicable, that we have to see. And in our exam point of view, which type of questions will be come to your analysis, that is important. First, there are types of the and stages of the Muslim laws are there. Personal law is regarding to the family laws, regarding to the adoptions, regard to the inheritance. So while we are giving the exams of the family code, we have to see laws of the family, and it is not related to the inheritance. Inheritance part is for the civil court jurisdiction, and inheritance not comes under the family law. So in family laws and family law examination, judges point of view, what kind of questions will be come for your examination is that regarding marriages, adoption, paternity, and maintenance, as well as divorce, talaq, meher, and custody of the children. So these parts we have to cover in this chapter now. So firstly, from starting, so as I previously mentioned, who is Muslim? The Muslim is the person who is by birth, who believes in Allah and his prophets, and third is the conversion. So conversion part, if we come for the point of view, who can convert and what is the procedure of conversion, that we have to see. So conversion is the any person who believes in Allah and believes in prophet, he can be treated as a Muslim. So there is no any specific provision mentioned in any law or in Sharia or in any enactment which says this types of if he follows, then this person comes to under Muslim. Only the person, we cannot judge it, this person is Muslim or this person, or the self declaration by the person that I am believing in Allah and believing in prophet, then he be treated as a Muslim. That is the part of conversion. But for the purpose of taking the benefits of marriage or benefit of the Muslim laws, if somebody converts in the Islam, then it cannot be said he is converted and he cannot take the fruits of that conversion. Now, if it comes for the marriages part, so in Muslim law, if you want to marry, the object of marriage is to procreation of the children and legalization of the kids or legitimate childs. That is the object of the marriage. Now, Muslim law is not a sacrament nor as a any rites. Okay, so as per Muslim law, for the purpose of marriage, there is no any uh, religious rites or kajis or nikhanamas. It is not mandatory. Okay, so then what is the mandatory? Civil. This Muslim marriage is the civil contract, treated as a civil contract. So what is in the civil contract? For that purpose, we have to see the provisions of the law of contract. So what is the contract? Basically, what has to be done? First, one party has to approach to the another party regarding the proposal of marriage. Means husband has to approach to the wife, or the wife has to propose to the husband, or both relatives of the each other can be approached to the either one party or another party to expressly their intention to marry with each other. So here, what is the important proposal made by the either party, and second, what is the ingredient? That the intention to marry. Okay. Now, who can make the proposal? A person who is of the sound mind. Any Muslim person who is of the sound mind can approach to the another party or give the proposal to the another for the marriage. This is the first ingredient. For what we say, Firstly, that is the proposer who approached to the another person regarding proposal of the marriage. And next stage, once proposal arrives or proposal receives to the one person from the another person, the consent has to be given by the another party, that is the acceptance. Now one party given the proposal to the marriage to the another party. If he is sound mind, then another party has give their consent or accept that proposal. Now the part of acceptance and proposal are there. So firstly, this proposal once receives to the one party and another party given the acceptance in the same meeting. Here is the condition of the same meeting. There is, if proposal given in a one day and if acceptance in another meeting or after 1 month, it is not called by the valid proposal or valid acceptance. So proposal and acceptance should be there in a single meeting. If single meeting, proposal and acceptance is accepted by both the parties, this is the first requirement or essential ingredient of the marriage. Now, as I told you, sound mind. So who can, if the person is not having a sound mind, then what is the losses? If person is not sound mind or unsound mind or lunatic or minor or unsound mind person, then if you want to marry with a person who is of sound mind, on his behalf, his elder person from the father side, they can give the proposal to the another person. Now here what is that? The person who is from the father side, if a minor is there, his father, father's father or brother, there are 3 degrees which is given. One, father can give the proposal of the marriage to the another party. Father's father can give the proposal to the another party, or brother of the minor or the lunatic person give the proposal to the another person for proposal of the marriage. Now, if there is the minor, as I told you, if minor also can perform the marriage with the consent of her or his father, father's father, or the brother. Okay. In short, while performing marriage, the person or a guardian from the mother's side cannot give the proposal of the marriage. Okay. Now, this is the capacity of marriage. Who can marriage? The person who is have sound mind and age of puberty. It means the person in India, and as per law, the age of puberty is minimum 15 years. So age of puberty is a 15 years. The person who attains the age of puberty having right to perform a marriage or having right to give the proposal of marriage to the another party. Okay. If the proposal party is a minor, if it is a girl or it is a boy, their guardians, parents, from the parent, from the father's side, they can give the proposal to the another party. Now, the proposal should be in one meeting. Third condition for the performing of marriage is the witnesses. So, proposal given to the another party should be before the 2 major or adult male members of the Muslim family. Now, here we have to mention 2 adult male members of the Muslim family in presence of 2 witnesses. This proposal has to be given, and the said proposal has to be accepted by the another party. Now, if the 2 witnesses are not there, then what is the condition? If 2 persons are not there, one person, one male adult person should be there, and if male one adult person is there, 2 female persons can be become witnesses. Now, in this scenario, 2 female persons is equal to 1 male person. Therefore, 2 female person and 1 male can become a witness for the Muslim marriage. Now, another question is this: if both the Muslim male person is not there, or if one male person is not there for performing marriage, then it is called as a absence of witnesses. And if the absence of witness for performing of an marriage, then that marriage is become a voidable, or we can say it a uh, marriage is a irregular marriages. Okay. So for performing a valid marriage, there is a proposal, acceptance, soundness of mind, age of puberty, and after that it comes for the marriage and witnesses. So in witnesses, one male member and two female member, or two male members should be there in presence of witnesses. This marriage proposal acceptance has been completed. Now there is no need for writing while performing the marriage. Usually we see in a practice there is a nikah nama in Muslims, but what it is not needed in the eyes of law or as per the Sharia Act or as per the Muslim personal laws. Only acceptance, consideration, proposal, and witness in presence of witnesses are there. It is sufficient to perform the marriage. Now, as I've used the word consideration, so what is the consideration as per the law of contract or as per the Muslim law? The proposer, whoever it may be, whether it is wife or whether it is a boy, the proposer and acceptance, this husband has to give the certain amount to the wife as a consideration, which is called as a meher, dower. So there are various types of mehers and dowers. I will complete this chapter again in the meher and dower chapter. So in meher, it is the consideration. Meher is the amount or the part of property or any valuable thing against which that wife is performing marriage with the husband. Okay, so this is the uh, necessities of the essential ingredient for the performing the marriage. Now there are how many types of marriage? This is one another part. So there are three types of marriages. One is valid. So invalid in Arabic word and in Urdu word it can be sahi. Sahi means true. Okay, so valid marriage is the true marriage. And what is the effect of that true marriage, or what is the effect of that valid marriage? Valid marriage having effect that she is getting right for maintenance, she is getting right for residence, even both the parties having right upon each other for their physical relations. This is the three types. And fourth right is after the valid marriage is right to iddat. So iddat is also we will cover in the chapter of divorce. But firstly, we are completing the part of essentials of the marriages. So in essential of marriages, in valid marriage, the effect of valid marriage or the fruits of valid marriage is are four types. Four type of fruits that can be get against each other. One, maintenance, another residence. Third one is the iddat right, and fourth one is the right to cohabit with each other. These four rights of the valid marriages are there. Then what about the void marriage? Void marriage is the marriage which is not legal. Means illegal marriages will called void marriages. Now, void marriage, when it can be void marriage? If it is void marriage, if the ingredients of the validity is not there, they're not legal, the object is not legal, or there are prohibited degrees of relationship are there. So consanguinity, fosterage, affinity, these are the grounds of the grounds on which these marriages cannot be valid. So the marriages which is not valid called invalid marriages or void marriages. So while as the point of our practice, void marriages doesn't come arise before us because void marriages having no legal right. Therefore, there are very some cases regarding that marriage is void, but generally valid marriages cases are there in court. And more important part is that the void marriage and valid marriage, between there is a irregular marriage, or we can say voidable marriage. What is concept of that valid and void? The marriage which is not legal and which is not void is called the voidable marriage. Voidable means we can void it or we can validate it. There are certain impediments under which that marriage can be valid or that marriage can be invalid. So what is the contents of the invalid marriage? When we can say that this marriage is invalid, or when we can say this marriage is valid? So there are some points which is given to the void. There are certain impediments under which this marriage can be voidable or it can be repudiated. So what is the concept of repudiate? Concept of repudiate is one person can deny their marriage itself. कि मेरा इससे शादी नहीं हुआ, I cannot, I never married with her, or I don't want to continue the marriage which is performed by me. So in which circumstances we can say this marriage is voidable or not binding upon both the parties. Now, irregular marriage is the irregular marriage. As we discussed prior, there are the witnesses. One witness, male and two female, or two males must be there. But if the absence of witnesses are there, or if one witness is there and another witness is not there, or if only two ladies are there and one male is there, or one male is there but no female members is there, or only single male is adult member is there, in such cases, in absence of the witnesses, such marriages can be voidable. But it can be regularized if the marriage or acknowledgement of marriage, both the parties given before witnesses, then it can be regularized. Means during the period, the marriage is not acknowledged by both the parties before the witnesses, it can be voidable. Either party can repudiate it. Either party can say this marriage is not valid and I am not bound to perform the marriage. This is one thing. Second, as per the Muslim law, husband having right or male member having right to perform the wives at a time, four wives, that everyone knows regarding this. Therefore, for the avoiding the controversy, if the Muslim male can perform a fifth wife, the fifth wife is having legal impediment for performing a marriage. So if we want to remove the impediment, if we want to clear that impediment, what he has to do, at a time Muslim male can have four wives. If he divorced the one wife, then that fifth wife can be a regular wife. So Muslim male can perform four wives at a time in a in his lifetime. So if he having performs a marriage with the fifth wife, and if he is having fourth wife at a time, and in such case, if he divorced the one of fourth wife, then fifth marriage becomes a legal marriage and it becomes a valid marriage. But if he not gives the divorce to the all of previous four wives, then fifth wife can say, or she have right to repudiate the marriage. She can say, no, I don't want to continue with the marriage relationship, and that marriage become a void. So voidable marriage is always says the marriage can be repudiated. It can be regularized, it can be avoided, it can be avoided. So irregular marriages having option to continue and not to continue. This is the second thing. Fourth thing, the wife or a lady undergoing the period of iddah, the any lady to whom her husband given the divorce, and after giving divorce, she is in during the iddat period. So that during that iddat period, if she performs a marriage with some third person, that marriage becomes a voidable marriage or irregular marriage. Now, if she marries with a person and at the time when she was going under the period, then now how it can that this impediment can be removed. The period of iddah, that is in various stages, iddat periods are different. So we will go through the iddat periods chapter, and I will explain what is the iddat period. But in this iddat period, if she performs a marriage with some another person, then after the iddat period, that marriage automatically become a valid marriage or legal marriage. So that is the impediment to difference in religion. So as per Muslim law, the person believes in Islamic laws, or the by birth she is Muslim, they can perform marriage. But if there is a difference in religion, if the male is Muslim or female is Christian or female is another than the Muslim marriages, then it can be said the difference of religion. If there is a difference of religion, there is the voidable marriage. Voidable marriage means they can repudiate the marriage, and there is the
सर सर आपकी आवाज नहीं आ रही सर. प्लीज वेट. सर डिस्कनेक्ट झालेत. एक 2 मिनिटं फक्त. हाँ सर आप.
हेलो, आ रही है सर, आवाज आ रही है?
यस 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 डिस्कनेक्ट हो गया था. कैन स्टार्ट.
ओके, ओके, सॉरी सर.
ओके नो इश्यूज.
So we are hello everyone, am I audible to everyone?
यस यस सर इट्स ऑडियो.
Okay, okay. So we are talking about the effects of the valid marriage and effects of the irregular marriages. So we were on the irregular marriages and effect of the irregular marriages. So irregular marriages can be continued with the removation of the impediments which is there. So first impediment was the absence of witness. Second one is marrying with the fifth wife. Third one is the person who is marrying with the wife who is undergoing the iddat period, difference of religion. And last one is not lawfully wedded or fully married. Full marriage, what is the full marriage and half marriage? Full marriage and half marriage is the marriage performed without consent or the person by the with the minor, and which is not having the consent for the marriage, and on her or his behalf consent is given by her father or her parents or guardians. Okay. So this is the voidable marriages. Now we completed the part of valid marriage, voidable marriage, and void marriages. So what is the effect of the valid marriages? So we have already covered the point. What is the valid marriage? The valid marriage, the completes all the fulfillments and essentials which is needed as per the Muslim law, we covered the chapter what is the needed for the essential ingredients of the Muslim marriage. So once it is performed the valid marriage, the rights comes against the marriages. So what is the right against the valid marriage? The right of dower comes to the wife. First right of the wife is the right to dower. Right to dower means the right to meher. That is the consideration part. Without consideration, marriages is voidable. Once it is paid, then the marriage become valid. So right to dower is the first right which comes after the valid marriage. Then second right is the right to maintenance. Third, right to maintenance. Then right to faithful relationship with each other. Then right to cohabitation and to observe it that if the in case of the divorce. This is the effect of the valid marriages. And what is the effect of the void marriage? Void marriage having no effect because this marriage is having no right at all because marriage itself is void. And what is the irregular marriage? Irregular marriages can be continued as a valid marriages after the impediments removed by the either party or both the parties. Then marriage become a valid and valid marriage having the same effect which is having the valid. Then third thing, in such a cases while we are dealing with the legal matters or while we are dealing in the cases the marriage is not performed at all but they live together for a long period, then in that cases what the Muslim law says, this is the another question. So if we are going through the domestic violence act, the concept of the wife is in the aggrieved person. So in that scenario, if you go through the Muslim law, then presumption of marriage is there. What is the presumption of marriage is there? There is no specific impediment is there, no specific ceremony was there, no specific proposal, acceptance or witnesses are there, but still they live together as a husband and wife for a long term, then the presumption of marriage consent is there. So in section 268 regarding the presumption of marriages is there. In that scenario, without proof of the marriage means there is a no proof of the marriages are there, no nikanama is there, no kaji was there, no any guardians are there. So what can be treated, or if the children are there out of that wedlock, so what is the presumptions of that marriage? So first, they should be stayed together as a husband and wife, and they have a relationship between each other as a husband and wife. So the definition which is covered in the Domestic Violence Act, it covers in the presumption topic of the Muslim marriages. Then, if either party not expressly or impliedly admitted there or acknowledged the marriage, but they have a child, then it can be presumed that they are a husband and wife. And third, acceptance given by the husband to the wife in front of the people that she is my wife, then it can be presumed that the wife is the husband and wife relationships are there. So these are the effects of the marriages and necessities of the marriages, and difference between the void and voidable marriages are there. Now, third thing and new chapter is that divorce. How the divorce under Muslim law has been taken or obtained by the other parties, and when it can be taken, who it can be taken, who can apply, and in which conditions both the parties can apply. Now, the controversial part regarding the Muslim laws are the triple talaq, which is banned by the government just days before or couple before month. It is banned by the government, and now nowadays triple talaq is banned by the government. Now, triple talaq means what, and types of talaq are what? Which kind of talaqs which can be given, and under which circumstances this husband and wife can take the divorce? This is the question. Now, giving talaq is the inherent right of the husband, which comes after the valid marriage. If valid marriage is there, and if husband wants to give the divorce to his wife, then he having inherent rights to give talaq to his wife. This is the concept of Muslim. Now, which husband can give talaq? Again, the question of sound minded is there. The person should be a sound mind, should not be lunatic or should not be minor. So if a sound mind husband wants to give a talaq to his wife, he can give a talaq as per his wish without any reason. This is his uh, inherent rights. Now, under which circumstances and for giving talaq, what are the ingredients to be there? When we can say this talaq is given by the husband is right or legal, or when it commences, or what is the right of talaq and when its commencement are there. First thing, types of talaq that husband can give a talaq by various types. Out of that, talaqul sunnat, talaqul biddat, talaq hasan, talaq hasan. These are the types which talaqs given by the husband. Now, talaqul biddat means the wrong form of talaq or bad form of talaq. Talaq, he has right, but the form of talaq is bad in eyes of law or in eyes of Shariat or in eyes of Muslim law. That is a biddat. What is that biddat? Biddat means a bad. So bad types of talaq is in a single sitting, if husband pronounces a triple talaq, 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 or he announces in a single sentence, says that I given you talaq in a thrice. This is the bad type. Or I given you talaq, I given you talaq, I given you talaq. If he pronounces these sentences in front of wife or in front of the witnesses to his wife, then this talaq amounts to a bad type of talaq, which is now banned by the government of India, and now it is Muslim women are protected from giving triple talaq by the husband. So now there is no question of talaqul biddat or talaqul void talaq. So this type of talaq is totally banned in India, and major of the Muslim countries also this type of talaq is banned. Now second talaq type, that is a talaq hasan. Talaq hasan means husband can give the talaq to his wife in a month single time. In month he can say I given you talaq, but when if both the parties are miserable in condition to continue their marriage relationship, or if wife is not able to continue the marriage relationship, so in this talaq, the object of talaq is to giving an opportunity to the wife to settle the marital disputes between each other. As per Hindu law or in family courts, we are heard the concept of cooling period. So in Muslim law, in the types of talaqul hasan or talaq hasan, there is a cooling period. What is the cooling period? So first husband is giving his wife a single talaq in a 1 month. If he given a talaq in a 1 month single time to his wife, then his wife has to aware that if I not repudiate or if I not clear my relationship with my husband, then second talaq may be given and my marital relationship might be uh, finished. So during that relationship, wife and husband both have opportunity to rectify their mistakes, to clear their mistakes, and they both can come to our mutual understanding that what the uh, mistakes they had did. But in this period, if this husband or wife came to know or came to conclusion that what the mistakes they had carried out, then what they will do, they can expressly, husband can expressly throw words, acknowledge the wife and say that I given talak to you, but I am taking that talak back and I am giving the opportunity to you. We will stay together and we will happy the enjoy married life. Then the talak given by the type of a hasan, it becomes a void, and again they can enjoy their married life. This is the first instance of the talak a hasan. If the husband not express any words to the wife, or he shames, or he thinks that why I have to give my words back, then he can impliedly take that talak back. With he can take the implied talak back? So just he having cohabited relationship with the wife, and automatically the talak given by the husband becomes a null and void, and automatically the wife comes under his marriage, and the eclipse of that talak becomes a irregular. Therefore, in talaq hasan, there is an opportunity to both the parties to rectify their mistakes and continue the married relationship. Now, this is regarding the single talaq. Now, in this talaq, ahsan type, single talaq pronounced by husband, and if he not taken the words back, or if he not cohabit with the his wife during that 1 month, then what is the next stage? In another period of tahor, what is the period of tahor? Tahor is the period of the menstruation cycle of the women. So in the period of that tahor period, or second talaq, first talaq, he given a 1 month, and after 1 month, if husband given a second talaq to his wife, then it is called the ahsan. So talaq ahsan in a single meeting, the husband has to pronounce the talaq in a single time with the in front of the wife, in presence of the witnesses. This is the talaq ahsan. And if he not taken back his words back for 2 consequential months, then it talaq continues. And after the pronouncement of the third month begins, and then husband, if third time pronounce the talaq to the wife in front of wife and says, I given talaq to you, it's now the ingredients of giving talaq is completed and iddat period starts. What is the iddat period? Once husband given a talaq to the wife, then iddat period comes start. Iddat period means from the day of given talaq, the period which comes, it is called the iddat period. Now, why the necessity of iddat period is there, and what is the effect of that iddat period? So iddat period is followed by the wives, followed by the lady, to see whether she is pregnant from her previous husband or not. It is for the paternity of the children if in her womb is there, children is there. So in the such cases, 3 months period is there. So after giving talaq means in talaq ahsan, 3 times he have to pronounce the talaq in 3 regular months. If one talaq is given in a January, and in February if he not gives the talaq, then talaq ahsan ingredient is not fulfilled. Consequential continue 3 months he has to say, and after talaq 3 months she have to undergo the period of iddah. Means 6 months the process of talaq is going on. So during this 6 months, husband has right to take back the talaq back, or husband and wife both have right to cohabit with each other. And if they cohabit with each other, then the procedure of talaq becomes invalid, and wife and husband relationship be continued together, and the effect of talaq become void. This is in a ahsan, talaq ahsan. Okay. Now, what is talaq hasan? Talaq hasan is the talaq in which single pronouncement is not there. In every month, husband has to give the triple talaq in front of the people. Thrice pronouncement is there, but thrice pronouncement has to be made in 3 months regularly. And effect of the iddat starts immediately. Because here thrice talaq is there, therefore they have to start it immediately, and immediate iddat period is that wife has to follow the iddat period. And during iddat period, that wife cannot remarry with third person. Because of why? Because we have to see, or law has to see whether she is pregnant or she is not pregnant, or there is a child in her womb or not. It is enacted, or the provision or the object behind this is, if child is in her womb, the paternity of the child belongs to whom? If she marries with the during the death period, and if she is pregnant, might be there is the possibility that another husband may not accept the paternity of that child. Therefore, in Muslim law, it is clear that after the talaq, wife has to maintain the iddat period for the 3 months. In case of death, iddat period goes beyond the 3 months, and it will become a 4 months and 10 days. If the husband dies, then wife has to follow the iddat period of 4 months and 10 days. That is the period of iddat. But in iddat period, if the person dies and the wife is pregnant, or in case of the talaq is given by husband, And in such cases, wife is pregnant, then this iddat period extended up to the delivery of the children. And after delivery of children, 1 month, 10 days, that is the 40 days, wife has to follow the iddat period. And the children out of that iddat period, out of that wedlock, having a paternity of the previous husband. So this is the concept of iddat. Why iddat period is followed? If there is a wife is pregnant, the paternity of the children goes to the uh, father, and there should not be any doubt in mind the children belongs to whom and father of the children is who. Therefore, this iddat period concept is there. Now, in talaq hasan, triple talaq, thrice pronouncement in 3 period of tahur, and after that the wife has to uh, follow the period of iddah. Okay, this is the talaq hasan and talaq hasan. This is the difference between the two types of talaqs are there. Now, in Muslim law and Shariat and all the laws are is Quranic laws and Shariat laws, which is enacted or which is followed from more than 1450 years or some near about 1500 years back. So in this 1000 years back, this Muslim religion given a right to the wives also to take the talaq from the husband. Not only the husband can give the talaq to the wives, but the wife can also ask the talaq from the husband. So wife having liberty to ask talaq from the husband. But the word talaq is not used. Talaq is only used if husband gives the talaq. If wife is asking for the talaq, then it is called a khula. But then now what is the khula? Khula is the demand of talaq, demand of closing the relationship with each other. That is the khula, which is demanded by the wife to the husband. Now, if husband want to discontinue the relationship, then he can give the talaq. If wife want to discontinue the marital relationship and get separated from the wedlock of the marriage, then wife can ask for the khula type of dissolution of marriage. So wife can ask the khula to the husband. Now the husband having right to deny the khula for a single time. But again, if wife asks for the khula is the type of talaq asked by the wife to get separated or dissolve the marriage. Okay. And if second time wife asks for the khula, the person not having liberty to deny the khula. Now they want to dissolve the marriage. Husband want to dissolve the marriage and wife want to dissolve the marriage. Or if wife want to dissolve the marriage, we can say, see, it is the type of khula. Means she want to be separated and she want to dissolve the marriage by way of khula marriage. Now in khula, she have to give something, her rights. So which right she have to give? So she have to give her right of meher to the husband. Meher is the part of consideration of the marriage. So this consideration she have to return back to the husband. In the khula, she have to give up her right about the meher to the husband. Or if both the parties not ready to give their right about the meher, then also khula can be performed. This is the type of khula. Now, if both the parties wants to be get separated and dissolve their marriage, then what is the condition in the Muslim law? In family courts, we are seeing we are filing the divorce by mutual consents. Or in Indian Marriages Act, there is the provision for mutual consent, divorce by mutual consent. So in Muslim laws also there is the provision regarding the divorce, getting divorce by mutual consent. In this case, husband and wife both are willing to get separated and dissolve their marriage is called the Mubaraknama or type of Mubarak. Mubarak means mutual consent. Mubarak means the willingness of both the parties. So in this case, husband and wife both are ready to dissolve the marriage by way of Mubarak. In this Mubarak, both having no rights on each other and they want to be get separated, it is the Mubarak. So majorly in Muslim law, if we see balance of the giving talaq rights to each other. Firstly, husband having right to give the talaq to wife by the way of talaqul hasan, talaqul ahasan, talaqul sunnah, and wife having right to give the talaq by the way of khula, and both the parties, if they are want to get separated, then there is the type of mubarak. Mubarak means talaq by mutual consent. If both the parties want to get separated, they can become a come and write the agreement regarding the mubarak. So mubarak nama is one kind of adjustment or one kind of agreement or one kind of mutual understanding between both the parties regarding getting separated from the wedlock of each other. This is the mubarak nama. So we can say this is the mubarak nama. Now, when wife can take the khula, or what is the ground to take the divorce? As we just seen, without any reason, husband can give the talaq. Means for getting talaq or getting separated from the husband, or husband wants to get separated, there is no any reason or no any ground or no any essentials in which cases husband can take the talaq. So husband can give the talaq for no reason. This is the basic difference between khula and talaq. So in khula, there are some requirements. There are some essentials in which cases wife can ask for the talaq or ask for the khula. Okay. In which conditions wife can ask for the talaq or ask for the khula? So there are 7-8 points under which wife can ask for the khula or wife can ask for the divorce. So what is that conditions in which case wife can file the case for the divorce or khula? In case if the husband is not treating her well, if the husband is not maintaining her for more than 2 years, wife has having right to ask for the khula, or wife can ask for the divorce as per the Dissolution of Muslim Marriage Act 1939. So in that case also she can file. Then if the husband is sentenced by any court of law and that sentence or imprisonment period is 7 years or more than 7 years, wife is having a legal ground that she can ask for the divorce or she can ask for the khula from her husband. Then next point is that when she can ask, if the husband is ask for the divorce as per the Dissolution of Muslim Marriage Act also and as per the Muslim laws also. Then if the husband treated her with the cruelty, then also wife having right to call for the khula, or either of the party, that is the husband, having a illicit relationship or adulterous relationship with any third person other than the wives, then wife have right to ask for the khula as per the Muslim law. Then one more thing is the unlawful comparison. Unlawful comparison is what? If the husband compares his wife with his mother or any female who is covers under the prohibited degrees of relationship. Then what is the prohibited degrees of relationship? Prohibited degrees of relationship is the relationship in which husband male cannot marry with a female in the prohibited degrees. Now, the which relations comes under the prohibited degrees? One, mother, sister, mother's mother, father's mother, then daughter, daughter's daughter. These are the some relationship which covers under the prohibited degrees of relationship. Any Muslim male cannot perform the valid marriage with the person who covers under the prohibited degrees of relationship. There are two types of prohibited degrees of relationships are there. One, the prohibited degrees of relationship with the relations from his relationship, and another prohibited degrees from the wife side relationships are there. The Muslim male cannot marry with a female who is covered under the prohibited degrees of relationship. Now, these prohibited degrees means mother, mother's mother, father's mother, then sister, sister's sister, foster sister, then consanguine relationship, then affinity. These relationships are called the prohibited degrees of relationship. as well as prohibited relationship covers the relationship belongs to the wife, wife's sister, wife's mother, wife's mother's mother, and wife's father's mother, and father's mother's mother. These degrees are the prohibited degrees of relationship with whom this husband, Muslim male, cannot perform a marriage. And if that husband or if that male compares his wife with the prohibited degrees relationship and says, you are like my mother, you are like my sister, you are like my mother's mother, if then in that case wife has right to ask for the khula, or wife can ask for the divorce on the ground of unlawful comparison. In law, in Muslim law, it can be said the zihar. Zihar is the unlawful comparison with the wife to the prohibited degrees of relationship. It is ground for the divorce, and in Muslim law, it is called the jihar. As well as wife can ask for the divorce on the ground of ila. Ila is the IAAA, in which it covers the concept of not cohabitation or deprived from cohabitation by the husband to the wife for more than 4 years. If the husband deprives his wife for the cohabitation for more than 4 years, the wife having right to file the uh, ask for the khula, or she can file the case before the court of law for getting divorce or dissolve the marriage between each other on the ground of ila. As well as what is the effect of the uh, talak, and what is the effect of the khula or mubarak, and what is the laws regarding the maintenance to the wife and the children. So in Muslim law, the woman having every right of maintenance during the period of iddat. During the period of iddat means the after giving talak, whether it is 3 months or it is 4 months, 10 days, the wife having right to maintenance, and it is the duty of the husband to maintain the wife during the period of iddat. It is mentioned in the law of Shariat and it is mentioned in the Muslim law. But there is the specific provisions for the maintenance and residence, and their all the expenses carried by the Muslim male as per the section 125 of the CRPC, and as well as in the section 12, 18, 22, 23, and 24 of the Domestic Violence Act. So under Domestic Violence Act and under 125 CRPC, all the rights of the Muslim female is protected as protected by the Hindu females. Means equal provisions applicable of the Hindu laws or the unique provisions of the common provisions of the other laws is also applicable to the Muslim laws. Therefore, there is no specific difference regarding the maintenance or regarding the childs and all to the Muslim females. There is no special provisions regarding the maintenance as per the Muslim law. But common laws provisions is applicable to the Muslim females, and therefore Muslim females maintenance right is protected by the legislation in these two acts. Then Muslim protection from the Muslim Marriages Act, protection from the divorce. This is also one act enacted by the parliament. So in this protection also, wife is having the right to govern by the law. If both the parties are agrees as they are governed by the personal law, they have to file the specific affidavit in the court by both the parties to govern by the Muslim laws itself. If both the parties give the affidavit in the court saying that they are Muslims and they should be governed and treated by the Muslim law, they will be treated in the as per the Muslim law. So both the parties has to give the affidavit in case of maintenance or in case of the any other law if they want to treated under the Muslim law. So these are the basic provisions of the Muslim laws regarding the point of view of the exams. Who is the Muslim? Conversion of the Muslim, essential of the marriages, effect of the essential marriages, effect of the valid marriages, difference between void and voidable marriages, maintenance, talaq, khula, mubarak, and types of talaq and dissolution of marriages. This is the part which covered for the point of view of the exams, and which comes for the adjudication before the family court, and as a family court judge, this points has to be covered. One more thing before the family court is regarding the custody and guardianship of the children. So who can entitled for the guardianship? This is the another question before the family court is treated. So general principles of the laws is applicable, but in Muslim law, first degree of relationship, second degree of relationship, and third degree of relationships are there. So in the first degree of relationship uh, of the children is mother and father, then mother's mother, father's father, father's mother. These are the first degrees of relationship. Second degree is the siblings, that is the brother, sister, and other relatives are the in second and third degrees. But first priority given to the first degree of relationship are there, and majorly as per the Guardianship and Wards Act, the benefit of the children has to be protected by the judges while granting the petition of the custody petition, or the custody of the children has to be given or not. So while you are becoming the judge, then it is the duty of the court to protect the benefit of the children, not the benefit of the husband and the wife, but we have to consider in the mind that the protection of the minor child and the benefit or the future of that child is protected with whom, husband or wife, that we have to consider, and as accordingly the orders has to be passed. Therefore, in Guardianship and Wards Act, or for the dealing in the custody petitions, the benefit of the children has to be taken care of from the judges. This is the basic principle of the custody. Now, what is the provision of the adoption? So in Muslim law, husband and wife both are not empowered to adopt the child from the third person. So adoption concept is not belongs to the Muslim law, and it not allows in the Muslim. So adoption procedure is not applicable to the Muslim laws. So this part is also not applicable to the Muslim families. So in Muslim law, marriages, divorce, maintenance, and custody of the children, these four parts has to be covered while dealing in the family adjudication and family judges. In point of view, if in a written exams, it can be seen, or in current affairs, or in current exams, or differences may be asked, void and voidable marriage, what is the difference? Then next question may be asked that whether husband and wife can ask for the divorce. Then what is the effect of the divorce? This question may be asked. For the short note, it can be asked what is the effect of the voidable marriage. For short note, this question might become, and most of the times it will be asked by the uh, examining authority, that is the High Court. So this question always asked, what is the difference between void and voidable marriages? Then write a short note on iddat period. This question is also very important for this. Then types of talaq and effect of talaq. This question may be asked. Then essential ingredients of the marriages and effect of the essential marriages. This question may be asked. So you have to consider for the broad question, essentials of marriages. This is the broad question. Then second broad question is types of talaqs and effect of talaq. And for short note, iddat period, difference of difference between the void and voidable marriage. This is the this can be asked for the uh, second question. That is the for short note. This question may be asked. Then conversion of religion, effect of the conversion of religion. It can be also asked for the uh, short note. So we have to consider all these points for the short note and for the exam point of view. So I completed near about Muslim laws, family related all the topics. So if anyone having some queries, uh, you may ask any question.
Yes, sir. There are few questions, sir. The first one, which is that what is the difference between will and gift, and whether there is a difference in Sunni and Shia law pertaining to will and gift.
Okay. So ma'am, this is not
This is
related
a
with the.
query of the student
I will
that is not
clarify.
related
I
to
will
the
clarify.
syllabus.
I will clarify this query also. But this is not a part of our syllabus. But I will then also I will cover this topic. Actually, gift in Muslim law, gift and in general, gift and hiba is the two different things. In gift, if the property is self-acquired property or the property belongs to any person, it can be gifted to the third person. This is the general principle. But in Muslim law, Muslim male or female cannot give the property more than one third property of his self-acquired property or the undivided property, whatever it may be, without consent of the uh, other co-sharers of the property rights. This is the basic difference. Whole property Muslim male cannot give, or Muslim person cannot give the whole property to any person by the way of hiba or by the way of gift. This is the basic difference between gift and hiba. So hiba, there are two types of hibas, or two types of gifts can be given in Muslim law. One is the oral gift and another is the written gift. In oral gift, there is no question of any evidence, but there should be the witnesses are there, and all the properties should be uh, valid and legal properties are there. Disputed properties cannot be given in oral hiba. But in hiba in writing or gift in writing, there should be the specific degrees of the relationship, and they have right in property. If wife is there, son is there, daughter is there, everyone is having right. But the person who is gifting the property, self-acquired property, they can only give the property 1/3 of his share to the any person, but not more than that.
Next question is, sir, Bohri community comes under which caste of Islam? I know it is also not directly connected
No,
to
no,
the syllabus.
okay, it is not covered with the syllabus, but Bohri Muslims is covered under the Shia laws.
The next question is pertaining to adoption. Does Kara applies for Muslims for adoption?
Yes, yes, please. Pardon, ma'am, I
Does
not get it.
Kara, CARA, Kara applies for Muslims for adoption?
Yes, Kara is applicable to the adoption, but in Muslim Shariat law and in personal law, Kara is not applicable and adoption is not valid as per the Shariat laws. But Kara is the arrangement made by the Muslims for the adoption, but adoption is not allowed as per the Muslim laws.
Next question is a question pertaining to the practice, and therefore I am not taking it. The other question is whether wife is entitled to maintenance under section 125 after divorce. That actually has been answered in the previous lecture.
Yes,
As far as 125 is concerned.
Then also I would like to answer this. The status of this question was in two stages. Before Shahbanu case, the stage was different, and after Shahbanu case was different. So before Shahbanu case, there was the just I explained in my previous my lecture that both the parties has due to an affidavit. But in now stage, various judgments of the Supreme Court and High Court is there. After the divorce, also this wife have right to file the case under section 125, and now under 125 Muslim wife can ask for the maintenance. This is the settled principle nowadays.
In which court a Muslim husband can file for divorce? It is in the family court.
Very good question, ma'am. And multiple times this question is asked by the asked to me by the various advocates are asking me whether if Muslim male wants to take the divorce, then what is the procedure? Very good question. Because in Muslim Marriage Resolution Act 1939 or another any divorce laws are there, but in that laws nowhere mentioned that Muslim husband can file the case for divorce. Then why this situation is there? Because the concept of Muslim law, if you goes through the concept of the Muslim law, Muslim male having inherent power to give the divorce to his wife. Therefore, there is no specific provision regarding Muslim male has to approach to the court and take the divorce. This is the basic difference between the Muslim law and Hindu law. Muslim male person having inherent right to divorce his wife. So he can give the divorce by ways which I elaborated. Then also, what is the practical approach? Suppose Muslim male wants the decree from the court about the divorce, then what he has to remedy? This is the question. Muslim male having an inherent power, he given a talak, he follow the ways of the divorce, but he want the decree from the court, or if you want to remarry with somebody else, and that lady or that family of the lady asking for the decree of the divorce, आपका divorce हुआ है मुझे दिखाओ, then I will marry. This is the practical question. If it arises, then what is the remedy before the husband? So in this situation, ma'am, we have to that husband has to give the one notice to the wife through the talak Hasan or talak Hasan, regarding he has given talak to his wife, first talak, second talak, three talak. So he has to give the three notices of his wife to his wife regarding the giving talak. So in that notice, it has to be clearly mentioned that the his intention that he is giving talak to his wife. If he give the talak first notice, second notice, and three notice, all three notices has to be given in the 3 periods of Tuhar. That is 3 periods of the menstruation cycle of the his wife. After these three notices, the procedure of the talak is completed. Now, the marriage is the Muslim marriage is the civil contract. So he has to approach to the family court for declaration of divorce. I given the talak to my wife. I given the talak to my wife. This is the copies of these three talak namas, and now she is not my wife. So declaration has to be given. So family court goes through the provisions, goes through the contents of that notices, and after family court satisfies that the talak procedure of talak is completed, then family court pass the order or the declaration that talak is fulfilled, and then he can take the decree from the family court or from the where the family court is not there, then civil court senior division has the empowered to
Yes.
give the decree of the divorce. Yes, next question.
Thank you, sir. Thank you, sir, for answering these questions. I will request Sharad sir to unmute the for the vote of thanks. Sharad sir.
On behalf of, shall I start, madam?
Do it, do it.
On behalf of Bar Council of Maharashtra and Goa, I would like to thank Advocate Sadikali sir for giving us information about the Muslim laws. Sir, your lecture was very informative. You have elaborated the meaning and procedure of marriage and divorce under Muslim law. I would also like to extend my gratitude to the chairman, vice chairman, and all the members of Bar Council of Maharashtra and Goa. I would also like to thank Dr. Uday Prakash Varunjika sir for coordinating this lecture series. And lastly, I would like to thank all the participants for participating in this lecture series. Thank you so much.
Sharad sir, close करा.